I'd like to backtrack a little bit because we've talked throughout these segments at one time or another about refusal for one reason or another to take various sobriety tests. You don't want to blow in a certain device, you're afraid of needles, don't want to take the blood test, whatever. But let's talk now about what if you've done that? What if you've refused at some point? We're there getting ready for trial, we've got all these issues that we're trying to take care of. What happens? I mean, do you get a separate hearing about your right to refuse, or how does that happen?
Well, and that's where I want to really emphasize again, this is one that I see a lot of lawyers miss. Parallel with the criminal case that's going on in court, there is an administrative hearing going on at the Division of Motor Vehicles. Now, it's not a hearing until you request it. What happens is a police officer will fill out an affidavit saying you refused a chemical test. That will get sent into the Division of Motor Vehicles. The Division of Motor Vehicles will then generate a letter to you saying you've refused a chemical test based on this implied consent law. We're going to take your license away for a year unless you want a hearing, and you got to ask in the next 10 days.
And sometimes there's just so much going on. You're getting ready for trial, you're worried about if you're going to get a conviction, that you're saying it sort of falls through the cracks, that you don't do the hearing? Or?
I see it fall through the cracks with a lot of people in a lot of cases. Now, I don't let it, but it's one, and also it happens a lot of times where people don't come see a lawyer until a month, 2 months after the DWI. Gee, my court date isn't until 2 months from now. I'll go see a lawyer the day before court and get them hired. No, your rights run from the minute you get that letter from the DMV. So you only have 10 days to request a hearing, and that's all done out at the Division of Motor Vehicles. So at the same time, you've got a criminal trial going on, and I'm going to jump track a little bit. This refusal under North Carolina law, the DA can argue that it's evidence of guilt.
Sure, but what happens if the hearing collaterally decides that you did have a right to refuse?
Well, that's a good question. I think if you win out at the Division of Motor Vehicles at this administrative hearing, you can get a ruling that it was not a willful refusal, and then they can't be used against you in the criminal. There is collateral estoppel between the two different hearings.
So much to think about and so much to do. And that brings us to our final segment coming up, which is getting you ready for trial, preparing for trial. We'll talk about that next.